Good morning. I'm going to present a topic on Contract Act. A contract means an agreement between parties reduced in writing, giving effect to the purpose of parties. Section 2, subsection H of the Indian Contract Act 1872 defines a contract as follows. An agreement enforceable by law is a contract. Two essentials for a contract are an agreement and agreement should comply with law. So, what is a contract? Broadly speaking, a contract is an agreement made between two or more persons to do or to abstain from doing a particular act. A contract invariably creates a legal obligation between the parties by which certain agreements are given to one party and corresponding duty is imposed on the other party. The law of contract is the most important part of the mercantile law in India. It determines the circumstances in which the promise made by the parties to a contract shall be binding on them and provides for the remedies available against a person who fails to perform his promise. The law of contract is contained in the Indian Contract Act 1872, which deals with the general principle of law governing all contracts and covers the special provisions relating to contract like bailment, pledge, indemnity, guarantee, and agency. Section 2, subsection H of the Act states that it is an agreement enforceable by law is a contract. Let us discuss these two elements in detail. That is, every contract thus combines two essential elements, agreement and obligation. It creates rights and obligation between the parties to the contract at which all correlative in cases parties refuses to honor a contracted obligation, it will give right to of action to other party also. And next one, what are the essentials of a valid contract? So uh, we can say that a contract it contains of two elements, that is agreement and agreement and agreement enforceable by law. So here the essentials of a valid contract includes an agreement enforceable by law is a contract. An agreement in order to be enforceable must be have certain essential elements also. According to section 10, all agreements are contracts if they are made by free consent of the parties competent to contract for lawful consideration and with a lawful object and are not hereby expressly declared to be void. Thus, an agreement becomes a valid contract for that it has the following elements. And the following elements should be proper offer and proper acceptance. Next one is intention to create legal relationship, free consent, capacity of parties to contract, lawful consideration, lawful object, agreement not expressly declared void, certainty of meaning, possibility of performance, legal formalities. So the essentials of a valid contract include the act of abstinence, which is consideration for the promise should be done at the desire of the promiser. It should be done by the promisee or other in India. Privity of consideration is not applicable. That is, consideration can be moved from one promiser, promisee or by third party to what it is not in the third party is a minor. The consideration can be past consideration, executed consideration or executee consideration. And there are two elements for a basics of a contract, that is offer and acceptance. Offer is a proposal and its acceptance is universally acknowledged process for the making of an agreement. This is the starting point. Section 2 subsection A defines proposal. It is the manifestation of the offer's mind with respect to the agreement. It can be both positive and negative, that is to do or not to do something. This particular manifestation is towards a specific party with a view of obtaining the assent of the specific party to the particular act or not to do an abstinence or act. Acceptance means accent should be significantly expressed by the act or omission by which the party accepting intends to communicate his accent or which the effect of communicating it. So these are the basics of a valid contract. That is, offer and acceptance are the two basics of a valid contract.